Good afternoon. It's April the 1st, 2024, and this is a bill hearing from the House Judiciary Committee. We have quite a few pieces of legislation to have hearings on this afternoon. We'll start with Senator Watson, please, if we could have him come up. Is he here? Are you presenting the bill on his behalf, or is he coming later, or no? You're going to present it on his behalf? All right. There are people who are testifying in favor, so we'll hear from them as well. Jason Shoemaker, Kaylee Locklear, Mike O'Halloran, Melissa Wade, and Justin Rice Moore. We'll bring everybody up. If you need to add a chair, that's fine. We'll hear from Senator Watson's aide first, though.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the House Judiciary Committee. Clayton Jackson, Chief of Staff to Senator Watson, here to introduce Senate Bill 100 on his behalf. 4 months ago, 3 suspects, ages 18, 19, and 26, were caught with over $10,000 worth of stolen merchandise. They were connected to 10 separate thefts that occurred during a 2-week period. 2 shoplifters caught on January 31st in Leesburg, Virginia, who were involved in the theft of merchandise valued over $158,000. Why is Leesburg being mentioned? Because the 29-year-old female and 30-year-old male were both from Laurel, Maryland. In the fight against organized crime, it is essential to recognize that this is not a victimless crime. Every stolen item represents more than just a loss for businesses. It impacts the livelihoods of hardworking individuals and jeopardizes the economic health of our community. Washington, D.C. is said to account for more than 68% of the retail crime than you would expect based on the national average. And that has trickled into the state of Maryland. Again, this is not a victimless crime. There are several people here to speak on behalf of the bill and why it makes sense. And I would like to turn it over to them at this time. Thank you.
Good afternoon, Mr. Chair and honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are here in strong support of this legislation. I just wanted to start by saying you did hear a similar bill earlier this year, Delegate Toll's bill. This bill does differ from her bill, and I'm glad to explain that. But essentially, this bill does 3 things. It creates a definition of organized retail crime. It allows for data collection to occur. And then it also allows that in a 90-day period, theft may be aggregated across jurisdictions. And I'd refer you all to our written testimony that you have before you. That details national and state efforts, as well as legislation that has passed at the national and state levels. And you also have information from the Attorney General's office I'll talk about. Congress has passed laws along with 32 states, both red and blue, and they've acted because of the impact that store closures have on communities. And we talked about this before. Higher prices, less tax revenue, costs to our judicial system, economic impacts on store losses, other crimes that are fed by shoplifting, and of course, access to food and pharmacies in our communities. Questions were brought up previously about joining charges together, and the Attorney General's office has confirmed in writing that they find no due process or constitutional issues with respect to joinder or venue provisions in the bill. I know we're glad to answer questions about that. The state's attorney's office is too. And again, I'd refer you to that letter in your testimony. We urge the committee to support this very important piece of legislation. It's a growing problem. I've been working on it here in Maryland alone for 8 years now. Our surrounding states have passed laws. We urge you to help us solve this issue. Thank you.
Good afternoon, Chair, Vice Chair, and members of the House Judiciary Committee. I'm Assistant State's Attorney Jason Shoemaker back before you today, and I'm here on behalf of the Frederick County State's Attorney's Office as well as the Maryland State's Attorneys Association to support Senate Bill 100, seeking to add that crime of retail theft to the Maryland Criminal Code. I note that our retailers have been crying out all over the country, asking for help combating this growing criminal trend, and Senate Bill 100 is Maryland's way to do just that. As I know you've heard multiple times this session, this crime is a plague to the retail stores in our communities. And for a myriad of reasons over the course of my 20+ year career as a prosecutor, I've seen both the prosecutions of and consequences for retail theft steadily decreased. Unfortunately, the criminal element has taken note of this as well. They know that engaging in large dollar, multi-store retail thefts carries far less consequences than committing a robbery. At the worst, they could face multiple prosecutions in various jurisdictions for individual thefts from a retailer, and in their best case scenario, they will never even be charged. That makes this type of crime both attractive and profitable to a cross-section of criminal actors. It's my hope that Senate Bill 100, should it become law, the attention that it brings and expanded venue provision will result in a recommitment of all retailers to support, law enforcement to respond, and then prosecutors to pursue these offenses in the courtroom, with the goal that these efforts will make this type of crime less appealing as we charge, prosecute, and hold these perpetrators accountable. We do have a statewide organized retail theft task force that Maryland has put together that consists of designated local, state, and federal prosecutors who stand ready to encourage and collaborate with one another on these prosecutions throughout the state, and it will work to implement best practices. We certainly do thank the committee for taking up this bill for consideration, and to the senators for introducing it, and we ask this committee to issue a favorable report on this bill. Thank you.
Good afternoon, Mr. Chairman, members of the House Judiciary Committee. For the record, my name is Mike O'Halloran, here today representing the Mid-Atlantic Petroleum Distributors Association, which includes convenience stores and service stations throughout the state of Maryland. And we are in full support of Senate Bill 100. Just to give you an industry perspective, what our locations are seeing more and more are thefts not only of merchandise in the store, but in particular ATMs. Unfortunately, it's become all too common to see on local news some of these sorts of activities, so that we feel that with this bill in particular, because we are seeing this type of crime not just localized in one particular jurisdiction, but taking place across multiple jurisdictions. And what we also see is that it is organized. That we are seeing sometimes 3 or 4 man teams, each with a specific duty or job when they go into the store. One goes to the back, disables security equipment. The other one, holds up any employees, and yet another person actually goes ahead and rips out the ATM machine, the cassette, etc. So here's the thing about our stores, is not only are they places where you can go and get your favorite drink, your favorite snack, but they've also become the primary grocer in many neighborhoods. So that we feel that passing this sort of legislation is one more tool in the toolbox, as you've heard from the state's attorney and from my colleague from the Retailer Association. So we just want to give a perspective from our particular industry. So we do urge a favorable committee report. Thank you.
Good afternoon. My name is Melissa Wade, and I have 2 Ace Hardware stores in Anne Arundel County. One I have had for over 23 years, and the second one I just opened a year and a half ago. And I have to say, in a year and a half, we've already been a victim to this retail theft crime, the rings, 10 times in a year and a half. And as a business owner, and we're not part of a big company, we are a co-op, we're not a franchise, we don't have endless funds or stockholders. I'm the owner, it's me, everything falls on me. And so now at this location in Crofton, it's more becoming a concern, because the teenagers that we hire to be cashiers or to work in the store stocking shelves, their parents don't want them working there because they don't feel like it's a safe environment. So it's crossed a line that it's hard to repair unless we have your support. And I know that there's been mention of loss prevention, whatever our loss prevention people making or their wages. But the one thing I have to say is I am the loss prevention. It is me. I'm the one that has to go to court and hopefully get these people prosecuted and have something done. And and then I have to pay the witnesses to come. It's very, very expensive. And then when we go, they get it postponed. We have to go back again. I mean, it's an endless, it's being in business for yourself. It makes it really hard and discouraging. And, but when it starts to affect your employees not wanting to come to work, that makes it even worse. And
Good afternoon. My name is Justin Reismore for the record. Good morning to Mr. Chair, Vice President, and the members of the Judiciary Committee. I'm a member of the ICSC, respectfully asking for your support for Senate Bill 100, Criminal Law, Organized Retail Crime. The ICSC are members of the Organization for the Advancement of Marketplaces and Industry, made up of shopping centers, malls, and main streets, and the commerce they drive for the communities they create. We are really trying to reflect on the fact that organized retail crime is not just impacting our economy, but our communities more than anything. I'm a former law enforcement officer in the Metropolitan Police Department serving the Northwest Corridor of Washington, D.C. I was a midnight officer who experienced organized retail crime firsthand. One of the major cases that I was on was with the J. Crew on 14th Street, which had a loss of $15,000 of stolen property. The perpetrators were from the DC and Maryland area, which was something that was unfortunate because there was nothing that the retail store could do to obtain those assets again. Organized retail crime is not a petty shoplifting. It is coordinated, it is sophisticated, and it is targeted retail theft, usually carried out by organized criminals and networks. According to our National Retail Federation of Buy Safe America Coalition, over $100 billion in inventory was lost in 2022 alone. An 81% increase in retailers reports violence and aggression. Unfortunately, we had a loss of life in Oklahoma at a Home Depot due to a retail theft attempt. The gentleman passed away from his injuries. And 26.5% increase in organized theft incidents in 2021. We respectfully ask that you support organized retail crime, Senate Bill 100, and we favorably.
Thank you. This question is for Ms. Locklear. It's good to see you. I'm sorry to see you, ma'am. Again, I remember your testimony from last time. I think this is a good bill, Ms. Locklear, but I have one concern, and that is that you also teens will sometimes do things because they are experiencing food insecurity. And so my concern is that somebody goes into a 16-year-old goes in and steals a loaf of bread or a gallon of milk, and that follows him or her until, they're 50, 60. And so my question is, obviously there needs to be consequences, but there's no excuse for stealing a Black & Decker from our friend at Ace, but have you thought about how sometimes people engage in this, kids engage in this for food insecurity reasons? And have you had to talk to anybody about, the impacts on 15, 16, 17-year-old?
Yeah, Delegate Kaufman, thank you for the question and the examples. So what you're referencing is petty theft, plain and simply petty theft. That is not the intent of this bill. That is not what this bill is going to be capturing. Even if somebody went in a store every single week for a significant period of time, say every day of the year, and stole a loaf of bread, they wouldn't even be captured under this bill. So there are separate theft charges that would occur there. This bill would be about a prosecutor's office's ability to look cross-jurisdictionally at organized groups of individuals who intentionally cross borders to steal items for fencing operations to sell them for money and convert the goods into money. So a juvenile or someone is not likely to be caught up in this. I mean, first of all, you have to have a vehicle typically to cross jurisdictions and steal on these lists, but they are large groups of adults that find themselves involved in these organized retail crime rings and professionally steal repeatedly across jurisdictions in Maryland.
Thank you for clarifying. I feel serving on this committee as a non-lawyer, I get a law school education every day without the debt that comes with it. So thank you.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Two, if I may. One, are the ATM thefts covered by federal law?
Thank you for the question, Delegate. I recall, I think you asked a similar question. If it's regarding to, is this a federal crime because ATMs are connected to the federal banking system? I think the answer then, and I can double check and get back to you, but I don't believe so, no.
Well, let's double check and get.
I
back
will
to
double
me.
check. Yes, sir, absolutely.
And my second question is in reference to the comment about Leesburg, Virginia. Are you asking that the state of Maryland join charges that might occur in Maryland to other states' crimes like Virginia or something like that?
And we would not be able to do that. That's cross state jurisdiction. So we only have a venue provision in this bill that allows it to be so from Howard to Montgomery County. But once they cross the state line, that would be a totally separate action in those other states.
So why
somewhere.
was Leesburg, Virginia brought up?
I believe it was just as an example, but I will let the gentleman speak to that.
Because the individuals who were arrested in the Leesburg crime were from Laurel, Maryland. That was the sole reason.
Thank you very much.
Thank you, Mr. Chair, and thank you, panel. And I definitely echo the frustration that's taking place in the retail stores. I'm currently dealing with that in my district with stores, so I understand that there's a significant need. My question to the state prosecutor, can you talk a little bit about the escalation of crime? So these folks that are stealing from stores, the vehicles that they're using are stolen, and kind of the pattern, right? So you're talking about an escalation of a pattern that is taking place with organized crime. And separately to that, do the crimes rise to the point where they could be charged federally after a certain dollar amount?
So as I've learned as a prosecutor, I'm going to take your second question first. So what I noticed as a prosecutor is that whenever we hit thresholds, it seems the feds raise that, no offense to our federal partners, but we're talking hundreds of thousands of dollars. Most of these thefts that we're seeing are somewhere between $25,000 to $20,000 when we're seeing them go into a store. It's nothing for them to walk out with $1,800 to $2,000 from each store and then hit 5 stores in a day. So that's how we get to those totals. And then as far as the escalation, and I hope I didn't misspeak there, my point is that what we see is the volume of individuals who engage in this type of crime, because this type of crime is extremely profitable. You go commit an armed robbery, you're going to look at 5 years mandatory time in the state of Maryland if you're convicted. You go hit 5 stores, unless prosecutors are looking for these kind of groups going around doing this multiple times, it'll likely be a prosecution in Montgomery County, a prosecution in Frederick County. And we don't necessarily play that well in the sandbox together. We all have our own jurisdictions. This encourages us to do that. This encourages us to work together to consolidate that so that we can make sure that it's a uniform prosecution. Again, at the judge's discretion for joinder purposes, but certainly the goal is so that we can see that this is handled by one jurisdiction where possible. And that just reduces the effort on everybody involved in that process.
Thank you. Can anyone at Retail Association, anyone speak to the economic damage effect of that at that level?
Yeah, absolutely. I mean, the effects are all over the place. Everything from lost sales tax revenue, which I talk about all the time, but in communities, these are often larger stores that are anchors in your community. So access to food and pharmacy, I bring up all the time. I mean, quite frankly, we dealt with a couple of grocery stores this year that almost closed in multiple jurisdictions. For the record, I know I'm not in this committee a lot, but I never get up in front of committees and talk about the sky is falling and stores are going to close. That is not how we testify or talk about issues. This year was very real, and that numerous food stores almost closed in communities that then would not have access to a grocery store in that community. So that impact is there. The cost on the judicial system itself is there. You know, one of the things that Joinder does is it helps save money in the judicial system. Otherwise, there would be separate trials for every single charge. And so that judicial economy is achieved here. There's just numerous things that something like this will do and continue to do to communities if we do not have this tool in our toolbox. What we have on the books is not working. That's why we're before you. And we have repeatedly come before you for years. It's now over $100 billion is what this is costing us and the United States. And that is not just corporate profits. The impact is pervasive.
Thank you, Chair. Thank you for that explanation. I really want to thank you for coming back down to testify. Melissa, we've talked offline quite a bit as the store that you mentioned is in my district. Can you speak to the culture? You talked about the 10 different opportunities, the crimes. Can you speak to the culture of the store, the culture of the neighborhood? What long-term or short-term effect that might have?
Have on me?
On you, on your workers, on the neighborhood?
Well, and I'm not really sure how I should answer that, but the long-term effect, the cost of running that store, it's the budget to run it has changed because that I've even gone to the extent of hiring off-duty police officers to stand in the store. And that I have a very elaborate camera system, so that way we have great video surveillance of it. And that one of the incidents, a couple of my employees were injured and my husband was hurt, my daughter. So it's when I opened the store, it's a beautiful store. I loved it. And, I enjoy being there, or I did enjoy being there. But it's so different. The culture there is so different compared to my store in Cape St. Clair that I opened that, we don't, maybe it's because we're tucked back in a community that we're not experiencing this. The most we've had there is credit card fraud, which that can be, that's not even irrelevant to this. But I just, it's changed because it's making it harder to find people to work there. Like I mentioned, the teenagers, they don't want to work there. Or their parents don't want them to work there. One of my really good friends, her son worked there during the summer last year. And she said, I'm not comfortable with him working there anymore. So I think it makes it harder to keep the employees motivated. And some of them, because of having experienced it, now they, it's caused them too much stress. I'm not sure. Does that answer? Does that help?
Thank you for being here. Could someone describe how this is different from the House bill? I just want to make sure I understand.
Yeah, I'm glad to. So right now on the books, you have a theft scheme. And what's interesting about that law is, so say in Anne Arundel County, somebody decides to steal from multiple retailers. You can go ahead and use that theft scheme statute to aggregate those thefts together and charge them as one. Where we figured out we have a problem here is that theft scheme statute does not allow you to do that explicitly cross-jurisdictionally. So this bill that's before you is adding a new crime to be able to do that. Delegate Toll's bill was adding to the existing statute and did a couple of additional things that needed to be fixed. And they were technical changes, but had to do with the Justice Reinvestment Act, and changes that didn't occur in other areas. So those are the big differences between the two bills. Technically, this is creating a new crime. We more so are proffering that it's closing a loophole that exists in the statute.
Thank you.
Thank you, Mr. Chair. And I may have a few questions. And the first one is going to be to Mr. Shoemaker. You mentioned that the state's attorneys were prepared to exercise this new prosecutorial tool. Could you kind of go into that a little bit more? I think you mentioned that, correct?
Yeah, that's correct. And we have what has been created as a statewide organized retail theft task force that has basically prosecutors designated from local, state, and federal offices. And so then what would happen is that we would work together. So in other words, what's working in other states around the country, and then working just together. Again, what I said is we don't play well in the sandbox together. This will encourage that communication and collaboration, again, for the benefit of judicial resources that we're not using so much, that we're not prosecuting individual retail thefts. Again, the criminal element tends to be rather smart. They realize if they hit 5 different counties, that's going to result in 5 different prosecutions, whereas this venue provision will allow us to consolidate them into one jurisdiction for prosecution, which again, for everybody involved, even the defendants to an extent, having one case as opposed to 5 different cases around the state, it will be more conclusive and be able to get their matter resolved in a more timely fashion.
And today, how do you do that at all today in terms of that coordination in any significant way?
The only time that I see that done right now is for a problem-solving court situation where someone may commit an offense for me in Washington County and Frederick County. They live in Washington County. I may coordinate with a prosecutor in Washington County to allow them to go into a drug treatment court program in Washington County. But as far as cross prosecutions, I would contend that most of us kind of focus on our own county. This encourages us to look a little larger than just what's happening in our own county.
So as people talk about the need for this, that to me is a real example of why there is a need for this. Now, this is the question for the industry. How will the retail industry work with law enforcement if this law were to come about? Is there an effort on your part already to kind of figure this out?
Thank you so much for that question. So since 2017, since Justice Reinvestment Act, we made a commitment in this state to host a yearly conference, and we bring together law enforcement, folks from the judicial system. So that could be prosecutors, it could be paralegals that work on their teams. It's a variety of individuals. And then we bring our asset protection and loss prevention folks from across the state. And we have meaningful conversations about the different types of organized retail crime that's going on. So everything from gift cards is a massive international industry that's going on, to some of these smaller, more local, gang-oriented types of groups. But we made this commitment, and we will continue doing this to help educate and bring together all of these different folks. So that's something that we've been doing for some time. The other thing that I had brought up before I actually shared this with the chair is we met with this past year all of the prosecutors' offices in major jurisdictions. My goal is to meet with all of them across the state so that every single one of them has my cell phone number. And the reason that we did that is because if there is a bad actor here, if there is a retailer that they can't get in touch with, or they're concerned hasn't produced evidence needed for the trial, that they can call us and say, listen, I can't get a hold of anybody at this company. Can you please help us? And we will help them do so. And the other message, and I wanted to make sure the committee understands this too, is there are a lot of resources that are involved here. We realize that we're asking for a lot. And so we're telling retailers, unless you plan on producing evidence and showing up in court and being a part of this process, please do not call law enforcement. Please do not involve your local prosecutors' offices, because there's a lot of other crime going on in companies that will come to the table and produce that information. So we are very clearly trying to send a signal to the industry that this needs to be taken seriously. This is definitely an opportunity to do so and a tool that we need, but do not bother everybody in this process if you don't plan on taking it seriously.
Thank you.
Yes, thank you, Mr. Chair. And I guess I just want to make sure that I'm clear. I'm looking at the value piece. I guess I'm kind of piggybacking a little bit on the question that my colleague Delegate Kaufman asked with regards to the valuation. So in the statute, it refers back to first section 7103 and defines value, which basically is just the market value of the property. So if I go and say steal, well, first, I don't even know why I'm about to use a weed whacker because I don't do lawn work, but let's say weed whacker. I don't know what the average cost. Let's say $250. for a weed whacker. I think that sounds reasonable. And I go and steal a weed whacker from every Lowe's in the state of Maryland, for an example. Are you saying that that $250 times, say there's a total of 15 stores in the state, would be considered retail theft, which would be a total, I don't have it, I went to law school, so I don't know. Thank you, $3,500. And and therefore I would be convicted of a felony with an imprisonment not to exceed 5 years.
So the question is yes, or the answer to that is yes, you could be prosecuted. Again, for us, I think it's a practicality thing. I don't know that if you do that in every county across the state, would it be possible? Yes. But am I going to, in Frederick County, drag witnesses from the Eastern Shore over to help me or assist me in that prosecution? I think what you're going to see is localized county groups where they're closer together and they're just hopping those couple county lines. That's where that consolidation is going to occur. So yeah, the bill has $1,500, as it must be more than that. So possible, but again, unlikely. I believe what all of us, at least as prosecutors, are looking for are these groups that are going around doing this. Certainly individual who's we're advised by a retailer that this person is a pain, that they are just hitting every store. We may give those a focus, but I know at least for us right now, just from a resource standpoint, it's important for us to look for the crews who do this. And this bill allows us to do that, focus on those types of offenses.
I'm just looking at the general theft article. So the first level is 1,500, but less than 2,500. And then the next level is, 25,000. And then the next level is 25,000, but less than 100,000. I guess your bill does not kind of go in line with the scheme that, and I'm looking at -7 104. Okay. Of the statute. And so why did you, I guess, set the amounts and the amounts that you did in your statute versus what is in 7-104?
So we didn't change a single threshold here. So felony theft threshold in this state is $1,500. Anything under $1,500 would be charged as a misdemeanor. Anything above $1,500 is charged as a felony, and felonies are categorized in 3 different ways. You have felony theft between $1,500 and $25,000, and that is the 5 years and $10,000 fine. Then you have theft between $25,000 and $100,000, and that's 10 years in prison and a $15,000 fine. And then you have $100,000 and up, and that's 20 years and then a $25,000 fine. So we actually aren't changing any of that there.
Okay. I guess that's where I got confused, because I was looking at, and I'm looking at on the bill, page 3, I guess starting at line 14, and it talks about what you said about the guilty of a felony not exceeding 5 years or a fine not exceeding 5,000 or both. But then in the next section on line 22, it says the section does not preclude prosecution for theft under 7-104. So are you saying that if I steal something between 1,500 to 25,000, I can get convicted under 7-104, and I can get convicted of this statute at 2, and those are going to be concurrent, or are those going to be, how does that work?
So the language at line 24 through 27 says that, and if line 26, under this section, if you're convicted of the retail theft charge, that it shall merge for sentencing purposes. So yes, that would be, this is really for us to document this is a retail theft. That's why we're pursuing under this statute or under that section for purpose of documenting it as retail theft.
Okay, so merge with one another. Okay, that helps clarify my concern. Thank you.
Thank you so much, Mr. Chair, and thank you all, Kaylee and all of you all for your hard work. Good to have you back. I think this is a very important piece of legislation to deal with a major issue we have in our community, and particularly those communities I represent where stores are closing, items are being locked away, where people cannot, shoppers cannot access them. I think we need to send a message, go back home to our residents and say that we hear you. We are doing something about this issue. So can you just, the first thing is talk about more detail, the letter from the Attorney General that's dated, I think in March after my bill was heard as well as Senator Watson's bill, talk in more detail about why this would be legal standing. And I know you mentioned it in your remarks, but I
Yeah,
would love
I
to go
did.
into more detail.
I did. And that's why we thought it was really important for all of you to have this before you. I know the issue of joinder had come up before. I received questions about it. And then we submitted it into testimony with you all. So it makes a couple of points clear here that I think are really important. First of all, it's that this bill is a may, it's not a shall. So you have this tool in your toolbox to charge, but there are certain things that have to be met here. And it's not changing existing common law or Maryland rule. So nothing in this bill is changing common law or Maryland rule. The bill, and this is back to the May point, the bill clarifies that there may be the joinder of charges relating to multiple thefts, but there does not have to be. And that determination is going to be made by the discretion of the court. And the court is going to go ahead and weigh multiple things here. The rule that allows this in Maryland law is 4-253B. And that rule is based on a policy of favoring judicial economy. And I referenced that earlier. And that's to save time and expense of separate trials under the circumstances that are named under the rule. But if it appears that any party is going to be prejudiced by joinder, that you can separate those trials. And the court is going to make that determination. They're going to look at whether or not together there could potentially be something separate that occurs if there are separate trials that occur. And all of this letter speaks to all of this and what the court is going to weigh when they're thinking about whether joinder would be applicable or if it's more appropriate to separate trials. You could probably explain this a lot better than me, but.
Yeah, I was just going to say that when there are multiple crimes like this committed across county lines, we would technically under Maryland rules be allowed to bring those other charges in, provided we meet that same mutual admissibility test. If it's showing some motive intent, some commonality. So this would allow this to happen anyway. This would just now allow the actual prosecution of those other offenses to occur across county lines as well.
Follow up, sorry. That's okay. Thank you for your indulgence. And I'm glad you said that because I was going to come to you next and talk about where you see, does this happen in any other crime? Do you do joinder in any other cases that you have in the state of Maryland or any other, just give me other examples other than this particular under than theft, like gang.
Okay, yeah, and that is actually the reference would be to the gang statute
Yes.
situation. So in other words, when criminal actors realize the loopholes in the law or how they can skirt the law or avoid prosecutions or consequences, then that's what this focuses and allows us to do is pull that kind of rug out from under them and says, it's not going to work. You're not going to this county, and this county. We can pull all those into one county and prosecute them. And again, the intention is to deter that type of behavior.
So we have done this before in other situations, other crimes.
Under the gang statute.
Thank you so much. And so the final question I have, I guess, is for Senator Watson's person. I know the answer to this, but just publicly, the idea was for us to have cross-file bills, and due to timing, it was very important to get them in, and we knew in committee we can make several changes. So would the senator be okay, which I think I know the answer to that, but just to say it publicly again, merging our bills and making these corrections and amendments done so the bills can match?
I'm sure he will be fine with that.
Okay. Thank you, Mr. Chair.
Thank you. I have some questions for the Assistant State's Attorney. So you have an item that's stolen in Baltimore County for $1,500, another in the next 13 counties, I guess, each of them for $1,500, and it totals more than $25,000. So under this bill, you can't get the 10-year penalty. Just to be clear, you're saying they can only get the 5-year penalty, correct?
It says it merges, and so I would say under the rule of lenity that they would get the benefit of that merger. So I agree with you that the
So
1,500
they
would
get the
be.
5-year penalty. So this doesn't create anything, just for the record. This doesn't create anything that says that there's a $25,000 threshold or a $100,000 threshold. So the situation, the world coming to an end scenario that was laid out by the senator's aide, where there was the theft in Leesburg, that kind of a theft where there were multiple thefts that totaled $100,000 would just be subject to the 5-year crime in Maryland.
I would see that as the merging into, and again, I believe under the rule of lenity, they are going to get the benefit of that 5-year maximum.
I mean, no disrespect to the senator's aide, it just, we get lots of worlds coming to an end scenarios in here. So I just learned a shorthand of that way. I guess the other questions I have in the bill, it says that an organized retail theft is a series of thefts. Would you define series of thefts?
Sure. So that can be defined a couple different ways but it has to meet the test, of course, for the judge for purposes of mutual admissibility. But if I see over a period of, and again, I'm arbitrarily picking a timeline, but let's say over a period of 2 weeks, we see individuals hitting multiple stores. And a lot of the times it's the same store as well. They're stealing the same types of items. They're using the same MO. We talked about having like a lookout or somebody going to the security door. Those are the kinds of things that we're looking for. So as far as a series of activity, multiple of the cases I've reviewed recently is 5 or 6 stores on the same day. That to me is like the most glaring of what I'm looking for as a prosecutor, because I believe there's not going to be, I'm going to reduce the questions of mutual admissibility when the people are wearing the same clothes, walking into the same store or a different store of the same chain multiple times over the course of the day, stealing the same types of items. So it can be broader than that. But I know at least from our perspective, we're seeing 24-hour periods. They're hitting 5 to 10 stores. And that is an easy focus, if you will, for me, an application for this bill.
I guess the question then comes to the 90 days that's in the bill that says that you can look at these thefts over 90 days. You're not seeing this as something then where you could have one theft 1 week, then another theft 2 weeks later, then another theft 3 weeks later, unless there was something particularly notable about the people and what they're wearing and what they're, so if they steal item A at one place and then a week later they're stealing item B at another place and then 3 weeks later they're stealing item C, that wouldn't necessarily fit under the bill. Is that right?
And I'm saying that would go into my calculation that I have to argue this to a judge why these crimes should be mutually admissible.
Because they're not.
That's right. And if they're
Because they
not,
wouldn't be.
that's correct.
So for the people who have come forward and said that this would stop these kind of consistent shoplifters in multiple different jurisdictions, that wouldn't necessarily come to pass. Is that right?
That it wouldn't stop
That
them.
it wouldn't result, the person who's 1 week, then another week, then 3 weeks later, it wouldn't necessarily go to that person. You're looking for the people who in a very short period of time conduct a series of thefts.
And I think for me, that's a practical evidentiary hurdle that we would have to overcome. In other words, it's easier when they're wearing the same clothes, driving the same car and hitting multiple stores at this, within the same day. And again, that's what we're looking for. We're looking for clear-cut examples of this is someone who this group got together, these 3 people got together, set out this day to hit as many, I'm just going to say CVSs as they could on this day. And then we are going to see that play out in the evidence that we review. And that's when this charge would be, in my mind, most likely to be applied.
So perhaps it wouldn't be necessary to have the 90-day requirement. Maybe it's more appropriate to have like a week or something shorter. But let me go to the next question, because you said the magic words motions hearings. So I guess my next question is, could this charge could be brought where? In district court or circuit court?
Yeah, it would have joint jurisdiction, concurrent jurisdiction with circuit and district.
Given the complexity of what would be necessary in these cases, would there be an objection to having these only brought in circuit court?
No, I mean, we've had discussions that we're talking upwards of 20 witnesses per each of these cases.
And probably motions hearings, something that in district court you wouldn't really be able to do on the day of.
These would
have all of these people showing up and you're going to have to try and figure out whether this actually is an organized retail theft, correct?
Yeah, you would definitely be looking at specially set trials if these were set in district court.
I think that the last question I have is you talked about issues related to coordination between state's attorneys' offices. And as a state's attorney, yes, I've called different state's attorneys' offices in the past And I've raised different issues with state's attorneys, particularly in burglaries that go across jurisdictions. I guess the question that has sometimes been asked in sort of in opposition to this, is this just a nicer way of saying that we're really trying to shop for the best venue?
So I don't see it as shopping for the best venue. In other words, where if I have one of these in Frederick County and my colleagues in Howard County have 4 with the same group, it just seems practical to focus those resources in Howard County and allow them to have the extra one from my county, or vice versa if Frederick County would have more of them.
All right. Delegate Moon, then Delegate Embry, then we're going to move on.
Thank you, Mr. Chair. I just have similar, very practical questions, I guess, for the state's attorney about logistically and technologically what's in place to make this happen. I guess if everything's happening in a very short span of time and it's the same actors, then I guess that's one, sort of hot pursuit where the law enforcement team conceivably is aware of all the activity. But if it's not necessarily happening so quickly in a period of time and it's more part of an ongoing investigation or monitoring, it does seem to raise questions. And I'll just ask whether technologically the offices are even in a place right now where their case management systems are probably different and not linked even as to these suspects. Would that be an accurate statement?
Yeah, it is. And I believe it's a headache at times for us to coordinate. I think, again, that's the purpose for the Organized Retail Theft Task Force, is to try to facilitate a smoother transition in those kinds of prosecutions.
I would just flag for you that MSAA was very opposed to us moving some of these technology and interoperability enhancements. The senator sitting behind you forced me to be a part of a whole summer study on, yeah. Senator Sidnor, I'll name him. I'll name him, but it was sort of a hot topic, but this bill and this question about how you look at suspects across lines was one of the use cases we had in mind, just so you're aware. And I'll put that back in front of folks as sort of one aspect of this that hasn't been finished.
Is it okay? I just want to close out since I do have that. Okay. Well, it's Delegate Embry second bite too, but guess what? You the chair, so I'll follow your rule. But okay. Okay. I just want to say this based off something that it's clear that, there may be a little apprehension from some folks in the room. I think any law that you make, right, it's not going to be perfect. It's not going to necessarily stop someone from doing something perfectly. But the idea is that you change behavior. What is the alternative? Do we close our stores? We see individuals in the community committing the crimes. I think we have a responsibility to offer an alternative to what is happening. And this is, I think, one of the best alternatives that we could offer at this point. Isn't that so?
Sure is.
Thank you.
That's fine.
Thank you. The chair's questions raised another one for me, and actually specifically your answer about the rule of lenity. So as I read this bill, it allows 2 courses of action. One is a charge under just theft scheme under 7104, and then you have available to you all of the penalties based on value. But if you also charge organized retail theft, then it doesn't matter what the amount is. You're limited in your sentence. Is that what you're saying? So that is a perverse.
And I don't wear a red robe, so I am forecasting that that's how I read this, my judges are going to say, okay, but you charged retail theft, so this person is facing the 5-year offense. So that
seems troubling.
It isn't, because the issue is for us, it's to draw that we're getting the benefit of the venue provision, if you will, plus we are focusing on what this is, which is a focus on retail theft. There was a question about buying a weed trimmer, stealing loaves of bread. That's not what we're looking for. We're looking for these organized groups that go around and commit this offense. So no, because again, we're talking about a time when, why don't we need this in burglary? Every burglary offense carries a possibility of a penalty of 20 years. So we don't need a cross venue, because if you commit multiple burglaries, would it be great? Would I love that as a prosecutor? Sure. But The issue is that that has enough of a penalty on its own. That 5-year penalty in my mind is significant enough that having someone face that on a prosecution is going to be a sufficient, if you will, deterrent from our standpoint for punishment and things of that nature.
But couldn't you achieve the same thing with creating the first part of it and then just using some version of your, the judge find that's organized retail theft? It worries me that you are now capping at 5 years organized theft in the state of Maryland if it is charged.
Yeah, I mean, okay, so as prosecutor, I'd say, great, let's raise it. I want to, if I can segue, I want to segue into something we said too. What I know is, like, to the chair's question, when you're talking about these individuals committing these offenses over a longer period of time, if we limit ourselves to a week, then the odds are they're going to hit a store in a week. The next week they'll hit another store. And so they'll change their behavior because that's what's happening here. So in my mind, yeah, limiting it to $5,000, not best case scenario for me as a prosecutor, but I like having this cross venue provision, the ability to charge and have that. Again, the $5,000 is there. That was what was given. And that's what we would be prosecuting under if we charge under this statute.
May I? You could amend it. I mean, time is not on our side right now, but I'm sitting here looking at page 3, lines 15 through 17, and you certainly could create, just like existing felony theft is tiered, you could add it in there. And we certainly don't want to start with the highest level there because that wouldn't have gone very well. So I'll just throw that out there too.
All right, I think we've bored everyone in the audience quite enough, so that'll be fine. Thank you very much. That concludes the testimony on Senate Bill 100. We're going to move on now. Senator Muse, are you here, Senator Muse? Come on up. Senator Muse has 2, starting with Senate Bill 118.
Thank you very much, Mr. Chairman, and happy Monday to everybody. And we have one more Monday left. It will even be happier for a long time. Mr. Chairman and the Vice Chair, members of the committee, I'm C. Anthony Muse for the record, here to support Senate Bill 188, driving offenses, expungement, and the ignition interlock system program. Now, as amended, Senate Bill 118 would expand the eligibility of convictions that qualify for expungement to include driving under the influence or impaired. The petition for expungement based on a PBJ under this section may not be filed earlier than 15 years after the person is discharged from probation. This was an amendment that this committee came up with last year, and so we put that in the bill, hopefully to satisfy enough to get some more votes. It was also the intention of this committee to add the requirement of the participating in the ignition interlock system program, and that amendment has also been added. That was one of the concerns that Mothers Against Drunk Driving had with this bill, but they sent an email saying that they now support this bill as amended. Additionally, the state's attorney can file an objection and petition the court. Therefore, the expungement petition is not automatic, and a person is not entitled to an expungement if they violate Section 1-902 of the Transportation Article. As you know, criminal records can prevent individuals from employment, housing, educational opportunities. In fact, more than 85% of employers perform background checks on an applicant when they apply for a job. So if you have a past criminal conviction of any kind, it's more difficult for you to obtain employment. Not to mention anything that occurs after an arrest is documented on an individual's criminal record, it will remain publicly visible via the Maryland case search until the charges and dispositions are expunged. So in closing, like you, I am the same. Many of us are not the same persons that we were 15, 20 years ago. If I were to tell you some of the things I did in college, you would throw me off out of this building, period. But you know, you grow, thank God, you change, and things happen that put you on a way, a path to be rehabilitated. Again, this bill does not allow repeat drunk drivers to have their records expunged. And again, it can only be expunged after 15 years. Therefore, I urge a favorable report of the.
Thank you, Mr. Chair. Just wanted to see if you would share some of those stories from your college years.
No way, buddy.
Oh, anybody else?
No way, buddy. They would throw me out of my church too. Oh, boom.
Before he loses his church, let's move on. Delegate Tomlinson with something on the bill. Hopefully.
Are you aware that the committee passed out, I believe we passed out a similar bill, but it didn't include the expungement language?
Right.
Okay.
Right. Yes, you passed out the interlock bill. I believe that was the one that did not have this language. Yes, we are.
Gotcha. Has there been any conversations with, I mean, I know we already passed that out, but I don't know, I didn't check the.
They're doing a voting list.
On the Senate side, it's on the
Yes, on
voting
the
list?
Senate side, on the voting list.
Do you know if there's been any conversations about being amended to more
There
mirror
has
your,
been, our Vice Chair Walt Stryker wanted to look into that as well.
to more mirror your
Yes,
bill? Okay,
correct.
gotcha. Thank you.
You're welcome.
And I think Delegate Tomlinson got to my point is you are okay with HB 867, which is your cross file, which
Very much
does
so.
not have it. So you're fine with that portion?
Yes,
of it
I'm
as
good
well.
with that.
Thank you, sir.
You're welcome.
Right, seeing none, that concludes the testimony on 118. We'll keep moving, go to 190. Gabriel's Law.
Okay, this is yes, should be a very easy one. Again, for the record, I'm C. Anthony Muse here in support of Senate Bill 190, law enforcement wellness requirement checks. We now call it Gabriel's Law. It is actually a cross file of HB 404, which this committee passed out, and my committee, JPR, passed out HB 404 on this past Friday. And for that reason, those reasons, rather, I'm asking for a favorable report. And if you do so, Delegate Graham, I'll be glad to discuss some of the things I did in college off record.
Senator Muse, always a pleasure to see you. How are you?
I'm well. How are you?
I'm doing well.
Good.
Yeah, I'm
Good.
doing well. Had to think about it, but yeah, I'm doing well.
I know, me too.
I'm also stalling because I'm trying to find a particular email. But I got a question asked regarding this bill and regarding adding some language regarding the firefighters.
Correct.
Yeah. So can you address that? Are
Yes,
you
and
aware-
I think that when the chief is here as well, we met, and the concern was that it appeared that it could have been interpreted that these calls can go into the fire department and they will be held responsible as well. And but the bill actually says law enforcement. It is only limited to law enforcement. And if this committee, in your wisdom, decides to put some language in, just to be clear, because there are some of the smaller counties where they get these calls as well, and the law enforcement and the fire department, they are all one. So if you want to put language in that simply says to exclude fire departments, or that it is only, which is what I believe the bill says now, only limited to law enforcement, then that would be great.
One more question on that. There's language in the bill that says unreasonably delay. And I think some folks were interpreting that perhaps as immediate. This is without unreasonable delay. And I think some people were interpreting that as immediately. So for instance, if firefighters were included in some capacity and they didn't immediately go in and wait for law enforcement, I think there was some concern about whether or not waiting for law enforcement is a reasonable delay versus an unreasonable delay. In your opinion, which is which?
Well, that's why we wanted to take out or be certain that it is only pertains to law enforcement. This would have nothing to do with firefighters getting the call. Of course, if they did, they could call 911 themselves. But immediate is reasonable. What's reasonable for that police department? What's reasonable for their resources, etc. Yes, you're welcome.
Thank you, Mr. Chair. I think Vice Chair answered most of my questions. I was just going to just add on that I know Senator Muse was an angel back in college. And so
Amen. Praise him.
and so that was all besides the firefighter question. So
Thank you.
Okay, any non-college related questions for Senator Muse?
Let the church say amen.
Delegate Schmitz.
I see that we have an amendment. We amended 404. Did the Senate adopt the amendment?
I believe there's some questions and the questions that are bandying about here a little bit are because of amendments adopted in the Senate that went beyond the amendments that we did when we sent the House bill over. And so that goes to the Vice Chair's questions in part.
Yep, makes sense. Okay, thank you.
Okay, thank you very much. That concludes the testimony of the Senate Bill 190, and we're going to go to Senator Muse's last bill, Senate Bill 449, please.
Thank you again, Mr. Chairman, Madam Vice Chair, members of this committee. Again, for the record, I'm C. Anthony Muse, and I'm here to support Senate Bill 449, criminal procedure and incompetency to stand trial dismissal. This is the amended version of last year's bill, and it would extend the amount of time for which the court can dismiss the charge of a defendant who is incompetent to stand trial and who is charged with first-degree murder or sexually assaultive behavior from 5 years to a reasonable time of 10 years. In addition, a victim or their representative has the right to petition the court for extraordinary causes to extend the time to dismiss a charge against a defendant found incompetent to stand trial for a crime of violence if the victim has submitted a written request to the Maryland Department of Health. Many of you remember last year, Mr. Troy Turner, he shared his story last year. And if you take a look at my testimony, you will see a newspaper article that references what he has been going through over the past 10 years. Now, 9 years later, the family is still seeking answers to Hagel's children's disappearance. My office and the Baltimore City State's Attorney's Office, along with the victims, have worked very hard on this legislation, starting with former Senator and now Secretary of State Susan Lee, who first introduced this years ago. And I don't want to belabor the point. I'll simply urge that this bill would be considered will be a favorable report. And there is a House bill, and Delegate Cardin is the sponsor of the House bill.
Delegate Kaufman.
Yes. I see here a letter of opposition from the Department of Health, and I was just wondering in the amendments and changes and through the legislative sausage making, if you've had, if you've addressed any of their concerns, because they say you would double the amount of time in which the judiciary must wait before dismissing the charges against the IST person. So they're not crazy about your bill, and so I would just if you had a chance to address any of their concerns.
We have, we're looking at amendments to put on this bill now.
Thank you, Mr. Chair. Thank you, Senator Muse.
Yes, and they just emailed that, and so we're looking at their concerns now. And I think we've come up with a way to address it.
So just for the record, a sexual crime under Title III, Subtitle III would be 4th-degree sex offense.
Correct.
Okay. Are there any questions, further questions for the panel? All right. Thank you very much. That concludes the testimony on Senate Bill 449.
Thank you. Good day to you all.
Thank you all very much. Senator Heddleman is the next person on the list, not to irritate Senator Sidnor, who has several bills, but because Senator Heddleman is the next person on the list, and I just, do what they tell me. And we'll hear Senate Bill 134, please.
Thank you very much, Mr. Chair. Madam Vice Chair, for the record, I'm Shelley Heddleman, Senator from District 11, and I'm pleased to be here to discuss Senate Bill 134, which would create an independent office of the Correctional Ombudsman. You heard the cross-file of this bill some weeks ago. This bill has been changed and amended and passed by the Senate and is now before you. We have worked very closely with the Governor's Office of Crime Control and Prevention, with this committee and with the House sponsor, and come to what I believe is consensus on this bill. And I'm going to talk a little bit about what the differences between the bill that you heard and this bill. One is, very importantly, it would create an independent unit. So originally the bill came in as an office within a unit within the Office of the Attorney General. This would really create a separate independent unit of government appointed by the governor, advise and consent by the Senate. It takes the Juvenile Justice Monitoring Unit similarly out of the Office of the Attorney General and puts it in this office along with staff and budget. It creates, it enhances an advisory board and gives it a little more meat on the bones to help to operationalize the office. And those are the biggest pieces, I think, that are different. Barely a day goes by where you don't open the paper and see something disturbing going on in our correctional institutions. And it is time for transparency and accountability. And that's really what this bill is about. And a correctional ombudsman will be accountable to the General Assembly and to the public, and most importantly, also, well, most importantly, the public, but to the governor, and provide a series of reports to this body about its work. So I'm happy to answer questions. There's obviously a lot more here, but I'm happy to answer any questions you may have.
Thank you. Members of the committee will be receiving an interlineated version with amendments that the chair intends to put forward and that we're going to discuss a little bit later today. And those amendments would change. There's language in the bill that talks about how the ombudsman is funded. It would limit funding from the Justice Reinvestment Board to the first year and the first year only.
Correct.
And then it would go to the general fund to be funded. And then it made some changes to the board that was there. One of the concerns, and I think I don't know that it was a concern that I had necessarily or anybody had that was different from anybody else. I think that we would want the ombudsman to be able to get experienced people to help get them up and running quickly. And so it allows for the introduction on the board of a couple more people who have experience in how these agencies work, so that they can help provide that information to get the ombudsman moving faster and better, and perhaps sooner rather than later. So you either have or will have those amendments shortly. They're sent. Okay. Questions for Senator Heddleman?
And I just want, if I could follow up. So I just want to thank you. I also want to thank Dorothy Lennick, who's the executive director of GOCAP, and council for being really helpful and quick in reviewing this. There is also language in the budget that is currently under discussion that follows what the chair said. And there is the understanding with the administration that this would become the responsibility through the normal budget process in general funds going forward, as well as there will be opportunities, and it's in the bill, to encourage application for federal funding.
Thank you very much, Mr. Chair, and so nice to see you, Senator. Just a quick question about the Juvenile Justice Monitoring Unit now being a part or being excluded from the Attorney General's office. Does it change the structure in any way or give it additional investigatory powers?
It doesn't give it investigatory powers. It does give him subpoena power
Okay,
also.
great.
And that, yeah, that was the chair of the Judicial Proceedings Committee. He felt strongly about that.
Okay, thank you.
Thank you.
Thank you, Mr. Chair. Hey, I have a question about the subpoena portion of the bill. So as I'm sure you know, individual agencies are when we think of when an agency says they have to talk to legal, they're referring to the Attorney General's office because the Attorney General's office supplies lawyers to every agency to represent the agency and give legal advice and whatnot. With what this bill would create, and I know it does say an individual, so an individual could be, I guess, anything from the secretary of the agency all the way down to a correctional officer. So let's say a correctional officer gets a subpoena, and they do show up. Will they be represented by the Attorney General's office? And then on the flip side, if they were not to show up, they did not show up and then they're held in contempt, would they continue to be able to be represented, or would the Attorney General's office continue to represent them as they would in a normal situation?
So I believe the answer is yes, which is one of the reasons that the Attorney General felt that there should be more distance because he felt there were conflicts. So they would still be represented by the Attorney General's office. Now, if someone failed to comply, there's a section, and you'll get this if you don't have the interlineated version, that the ombudsman could apply to the court of competent jurisdiction if somebody is not responsive. So they can go to the court to enforce.
All right, seeing none, thank you very
Thank you.
much. That
Thank you.
concludes the testimony on Senate Bill 134. Now Senator Sidner can stop being so antsy and come up to the table. He has 3 bills now that we've called him out from here and he's had to sit there quietly. We will take his bills now and start facial recognition 182. I'll do them in numerical order and yeah.
That works.
All right.
And I enjoyed your first hearing.
I'm sorry?
It's actually
You
interesting.
enjoyed the first hearing.
It's so interesting hearing how one committee listens to one thing and how we heard it and the discussion that goes on. It's just fascinating.
Wow. Well, let's see how we listen to your bills now. Senator Sidnor.
I'm hoping not to be too long. Welcome home. All right, Charles Sidnor for Senate Bill 182. This bill was the cross of House Bill 338 with Delegate Moon. And just to give everyone here some context, the impetus of this bill started when I was here in Judiciary. The past couple of years, it almost got through last year at the end of last session. I talked with Scott Schellenberger and said, look, and he said, if you put in the exact same bill that came out of the Senate, we won't oppose. I said, I promise I will not make any changes. I'll do just that. Anyhow, towards the end of this session, I think the NAACP Legal Defense Fund spoke with Delegate Moon. There was some amendment. It seemed that everybody was fine with it. I said, fine, put the change in. That's totally fine. Well, the modification wasn't quite right. So there is an amendment within, I believe, your folders from the Maryland Chiefs and Police Association, Maryland Sheriff's Association, which gives language that I believe all of the parties agree with, which I am fine with as well. However, the one sticking issue and Delegate Moon is aware of this. While the crossfire was over in JPR on Friday, we held it because there was a new I guess request to put a preemption language in the legislation, which I believe the Office of Public Defender initially thought was fine, but there's another well, they weren't fine with it, I'll say. They were not, well, you know, she called to the boss and realized that they were not fine with it. And so we held the House bill because the parties were supposed to be talking today. So what I would ask is I mentioned to Delegate Moon, we're giving them till Monday. Obviously, I don't think it's going to be something that they're going to see eye to eye on. I believe the party looking for that amendment wanted it to be a ceiling. I believe OPD initially looked at it as a floor, not trying to prohibit local governments from going a bit further. So again, with it being a delicate balance, it's not something that was expected. And I would ask that if it's not necessary, not to do it, because again, we need to have something in place for facial recognition. So with that, actually, I don't know how to say move favorable, I guess, with the Chiefs and Sheriffs amendment.
Questions? You now no one wants to ask you questions. That concludes the testimony on Senate Bill 182. We'll go
And I'm
now.
not going to ask for questions.
All right, Senate Bill 840, or I'm sorry, your next one, yeah, it's 840 or 551. 551. Sorry about that. Go to 551.
Yes, Senate Bill 551 is the cross of Delegate Kaufman's House Bill 801. I would just ask to move favorable. I think we moved the House bill over in the Senate on Friday. So if I'm not mistaken, I don't know if there was a letter that was different from the House bill and the Senate bill, but if we move this bill in the same fashion that we moved the House, then I'm fine. Yeah, I've had so many bills with, no, you know what, that may.
There's language on page 2 that would add, that said for civil matters.
Right. So
Discovery for civil matters.
Right, however it was that you all passed it out, I'm fine with it being.
The way that the House passed it out, or the way
Correct.
the way that we passed
What
it?
you all did, correct.
Okay. Questions for Senator Sidnor? I think they're basically identical, but okay.
Correct.
Oh, that was a different one. Yeah. Okay. Don't see any questions. Thank you very much. That concludes the testimony on 551. Now we'll go to 840.
All
It's
right.
a very questionable House sponsor, this bill. Senate Bill 840.
Senate Bill 840 is the cross of House Bill 1081, Delegate Phillips. I ask that this bill be conformed with the House bill that you all passed. We passed that out of Judiciary on Friday. Oh, JPR, I'm sorry. I'm back home.
So just again, to be clear, you're asking to conform the Senate bill to the House version.
Correct.
Right. Questions? Seeing none, thank you very much.
Thank
That
you all very
concludes
much.
Senator Sidnor's 3 bills. It's the vice. Do you have a question?
I'm sorry.
You
Senator, my apologies. I was,
You do have a question for the senator? Oh,
Okay.
said I had, but I don't.
okay,
That works.
go away, leave. Get out while you still can. Let's go.
Y'all have a good one.
I don't see the vice chair out there. I don't know that I see. No, not really. Do you, I don't know that I see other senators out there. Not yet. So we'll go to staff. Senator McCrae's staff is here on Senate Bill 468, please. Yes.
Good afternoon, members My name is Tamika Winkler. I'm here on behalf of Senator McCray. To introduce SB 468. We have Nina Thimlis here. Is a by request bill, and she would be able to speak on the bill.
All right. Good afternoon, Chair, Vice Chair, members of the committee. Nina Thimlis, Director of Government Relations for the Mayor's Office in Baltimore City, here to speak in support of Senate Bill 468. Senate Bill 468 is the cross-file of House Bill 614, but with some notable amendments that were made in the Senate. Those amendments add some additional time restrictions for the notification requirements for the private home detention monitoring agencies. The requirement would be upon determination that a violation has occurred of any prohibited zones, an immediate notification for any violations of tampering or a failure to maintain equipment. There will be a 1 hour requirement for the home detention monitoring companies. And then for any and all other violations, the requirement would be within 24 hours notice. The bill also adds in a provision to require that any knowing, if a company knowingly does not report within the required times, that there would be a civil penalty added into this version of the bill. I do just want to flag that the purpose of this bill is to help save lives. It is to ensure that the individuals who are under home monitoring are being properly monitored and that any and all notifications are being made within a timely fashion. I'm here to answer any additional questions that you may have, but would respectfully request a favorable report for Senate Bill 468.
So this is no longer really a city delegation bill. This is a statewide, this has a statewide impact. It's not just a city bill anymore.
That is correct.
All right. Given that that's the case, do people have questions? Here comes Delegate Phillips.
So I want to make sure on these reporting requirements, because we're dealing with technology and we're dealing with policy. At what point will the monitor know, particularly if there is a policy that says an individual, let's say, can go to work, right? Is it realistic to have an immediate notification versus some other period of reasonable time?
So under current law, all private home detention monitoring agencies are required to follow the individual requirements for each individual's probation or pretrial detention. So the home detention monitoring agencies already have information concerning any prohibited zones, any work allowances, any ability for that individual to be outside of their home base, so to speak. Also, I want to just point out that in the bill itself, it doesn't speak to the notification being required immediately upon the person entering into a zone or exiting a zone. It's after the detention company determines that a violation has occurred.
Thank you.
All right, right now. I'm all right now.
You're all right?
Yeah, right now.
Okay, never mind. Any further questions? Seeing none, thank you very much. That concludes the testimony on Senate Bill 468. We're now going to go to, does Senator Waldstreicher have staff here? All right, I tried. It's Senate Bill 373 is his, 858 is Senator Hester's. Come on up. Just as a gentle reminder for members of the committee, we don't ask our toughest questions of staffers because while they're wonderful, they got fewer votes, the senators they represent.
You can still ask
Please
questions.
go ahead.
Good afternoon, Judiciary Committee. My name is Damian Lang. I am Senator Katie Fry-Hester's Chief of Staff and a resident of District 46. Just saying. So good afternoon, everyone. Chair Clevenger, Vice Chair Bartlett, members of the Judiciary Committee. Thank you for your consideration of Senate Bill 858, which enables a person to bring a civil action for defamation against another who distributes a computer-generated visual representation that falsely depicts the person in a sexual manner. Websites and apps that use artificial intelligence to generate sexual imagery have grown in popularity since their inception. In September 2023, 24 million people visited websites that can manipulate images to make the person in the photo appear naked. Furthermore, from 2018 to 2020, the number of computer-generated pornographic images online doubled every 6 months. More recently, in January of this year, fake pornographic images of Taylor Swift began to circulate on X, prompting lawmakers to take immediate legislative action to protect individuals from computer-generated, non-consensual sexual images. However, this harmful proliferation is not limited to celebrities. The non-consensual distribution of artificially generated images has violated women's privacy, dignity, and security in numerous instances. These cases also lacked appropriate recourse, as there are frequently no adequate safeguards against this burgeoning crime within state laws. I have uploaded a presentation that we gave to JPR when we presented this bill over in the Senate. If you would like to view it, it's in your floor system. There are examples of AI generated images that I promise are non-pornographic, but they do show the growing capabilities of this technology that we need to be aware of and have proper safeguards in place for. So to address this growing problem, SB 858 will broaden existing criminal law by amending the existing misdemeanor revenge porn offenses, by adding computer-generated visual representation to the non-consensual distribution of sexual imagery. It will also enable victims to seek civil remedies through a private right of action for defamation per se, and enable further victim protections by restricting the availability of court-documented imagery from being viewed publicly. Now, this bill is very similar to HB 145, which this committee voted out favorably with amendments. Delegate Pippy, the Senate Judicial Proceedings Committee, and our office have worked together to identify the best path forward. While HB 145 is not a cross-file, these two bills aim to accomplish the same goal. And on March 27th, Delegate Pippy and the Senate Judicial Proceedings Committee agreed to conform HB 145 to this Senate bill. So we now leave this bill in your very capable hands. In closing, the rise of non-consensual artificially generated sexual imagery is only going to get worse as the technology becomes more advanced and accessible to the average person. This bill will not end non-consensual computer-generated sexual images, but it will give courts and victims the tools and resources they need to hold those who generate the images accountable for their actions. For these reasons, I respectfully request a favorable report on SB 858. Thank you.
I called the other two witnesses up. Ms. Shapiro is favorable. I have a sneaking suspicion I know what Ms. Jordan is doing and why she is favorable with amendments. Let's go to Ms. Shapiro first. I'm not sure I don't think that there's any hanky-panky going on here. All right, so that's fine. Ms. Shapiro.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee, Melanie Shapiro, Public Policy Director with Maryland Network Against Domestic Violence. I'm here in support of SB 858. I have been in communication with Delegate Pippy regarding his bill that you did pass out and adding on the civil cause of action, and supported his bill with the amendment to add on that civil cause of action. That's what this bill, certainly there's some slight differences between the definitions that I believe the intent can be retained. I believe there's a distinction in the penalties as well. But the ability for a victim to take that action upon themselves and initiate a suit is incredibly important. And so we are asking that you move favorable on this bill that retains that civil cause of action, having similar conversations to have that hopefully added. And while there are not cross files, there is yet another bill that is also very similar that is sitting, has not been voted on in this committee as well. Delegate Lopez has a bill that also creates a civil cause of action. But that is our hope. Victims of domestic violence unfortunately experience revenge porn, both actual images of themselves as well as computer generated images. This is an important update to the technology that we see now, and the remedy of the civil cause of action. So for all those reasons, we urge a favorable report.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We also support Senate Bill 858 with amendment. This is my last hearing in judiciary this session, so I also wanted to take a moment to say thank you all for listening to the really difficult issues that MCASA presents, and for all of your care and concern for survivors. So as my colleague Ms. Shapiro said, Senate Bill 858 is one of 3 bills on deepfakes, and this bill includes both civil and criminal remedies. I may have a slightly less rosy view of the action the Senate has taken. And I suspect that the action you took on House Bill 145 is perhaps the action you will continue to take on House Bill 145. But I also agree with Ms. Shapiro that both Senate Bill 858 and the bill you heard previously, Delegate Lopez's bill, House Bill 1062, includes civil remedies. And these remedies are enormously important to survivors. House Bill 1062 proposes civil remedies for deep fakes and for revenge porn, and both damages, injunctive relief, and attorney's fees. Senate Bill 858, on the other hand, only includes deep fakes, not revenge porn, and only includes damages, not injunctive relief or attorney's fees, which is how you actually access the courts. So MCASA is respectfully requesting that all three legislators be satisfied and that Delegate Pippy's bill continue to pass. The Delegate Hester's bill be amended to include revenge porn and injunctive relief and attorney's fees, and Delegate Lopez's bill also be reported favorably with the same contents as Senate Bill 858, which, just to make it even more fun for you all, they were originally intended to be cross-filed, but there was some sort of staff snafu. So that is MCASA's suggestion, because that would provide survivors with both criminal remedy.
I went on about how we're supposed to be nice to staff. You're saying there was a snafu. It's terrible. The vice chair, then Delegate Grammer.
So I just have one question for Lisa Jordan, since this is your last bill hearing for this session. Aww. You didn't come ask much, did you? So let's go back. I'm on this bill. I'm on the three bills, actually. So I just want you to, if you could take it slowly for all of us and go through those three bills once more so we can understand what the ask is that you're presenting with the favorable with amendment.
Yes, thank you for that. So House Bill 145 is Delegate Pippy's bill. You and the House of Delegates have reported that out favorably, and you removed provisions that would have added deep fakes to revenge porn, and instead you put deep fakes into the same section of the law with harassment. So you provided a lower penalty, but it's still better than we have now. So this is still progress for people who are victims of deep fakes. You have two other bills that include civil remedies. Now, Senate Bill 858 includes something similar to Delegate Pippy's bill, but I have been around a while and I don't think you're going to change your minds. If you do, I fully support that, but we have 8 days. And so you could take Senator Hester's bill 858 and provide a civil remedy. And you could take Delegate Lopez's bill and also provide a civil remedy. And Delegate Lopez's bill has a better approach because it includes revenge porn and deep fakes, and because it includes damages, attorney's fees, and injunctive relief. And really, if your naked image is up on the internet, injunctive relief is awfully important. So especially we want that. You could make Senator Hester and Delegate Lopez's bill look the same, and voila, all three legislators have bills that actually help survivors. So that would be MCASA's proposal.
Great, thank you.
There's one thing they say about this committee. We're just always about making people happy. Delegate Grammer, I didn't like the tone of this committee on that joke. All right, Delegate Grammer.
Thank you, Mr. Chair. You make me happy. Ms. Jordan. Oh, brother. Can you do me a favor and write that on an email? And do it so that I don't have to do any work and just refer to like sections and bills, so that if we wanted to forward that to the amendment office, I could do that very easily. Would that sound good to you?
I think that would sound just delightful to me.
Love
Delegate.
that.
And if you send me a Word version of Delegate Lopez's bill, I can send you something beautiful.
Amazing. Thank you so much.
Thank you to the Senator's assistant. Can you tell me where this file is that you said that you sent us? Is it in the testimonies?
Yes, it should be.
It's under what? What's it under?
It's under SB 858, House presentation.
House presentation.
Yes.
Thank you.
Okay, quick question. That's the PDF presentation that's saved on the floor system. Okay, it's the first one under Katie Fry Hester with PDF at the end. You're welcome.
Thank you, Mr. Chair. So I guess I understand the construction of compromise that's being suggested here, and it makes sense to me up to a point. And this is where I have a question. So it sounds like you're saying take the House criminal and the Senate civil, but there's 3 vehicles on which to do this. And so I guess if I were to try and request amendments, the safest way to ensure safe passage for all interested parties would be to make sure all the provisions are on the bills that enter in possession of the opposite chamber, which would mean to put the Pippy bill and the Hester bill together on both the House and Senate versions, as opposed to having the civil and the criminal split off into 2 separate vehicles. Does that sound correct? And this is if we're agnostic as to the Pippy and Lopez versions, they could all sail out in the same way, but I guess that's my question. Does that make sense?
I understand that procedural argument. I think that my thought was that because Delegate Pippy's bill is kind of close to complete and could simply be sent back, that you could accept those amendments and then make the civil amendments to the Lopez and Hester bill. You would have to do something to the Hester bill if you want to retain your criminal provisions on the Pippy bill. And additionally, although I have a great deal of respect for the bill introduced by Senator Hester, it really does need additional help to be effective. It doesn't have attorney's fees and it doesn't have injunctive relief, which is hugely important.
So for changing the Senate bill, we might as well put everything on it.
That's certainly one approach.
Unless you think the Senate's going to tank the bill over us putting that on there. Sorry. Okay, I'm done.
I fear we're making the chair unhappy.
We now in the bill hearing are straying well into procedural matters as opposed to what's actually in the bills. And so I'm going to cut this off a little bit and say we can figure out vehicles a little bit later. I think the Senate and the House have in different forms basically said that we understand what's important on the broader issues. That's what we have to figure out. And I don't know that I want to encourage Delegate Moon because we'll be here all day as he's trying to do that because this is what he loves to do. All right. With no offense, it's majestic to watch. I just don't have any more time. All right. Any other questions? I went with majestic with that deliberately. Seeing none, thank you very much. That concludes the testimony from on the 858. Now Vice Chair Waldstreicher is here. Senate Bill 373. This doesn't include a 99-year penalty.
It does not. Can we pause for a second? Can that be Delegate Moon's bumper sticker? Like David Moon for Delegate, majestic to watch. I love that.
There we go. Well, somebody will have that done in a couple days. All right, Mr. Vice Chair.
Well, thank you, Mr. Chairman. I hope everyone had a meaningful and happy Easter yesterday. It's a pleasure to be before you. I'm in the awkward position of asking that you not pass SB 373 in its current posture. Delegate Solomon came before you and did a great job presenting the original bill. The original bill was extremely comprehensive, but its complexity raised issues that this committee identified. And so on our side, we went back to try to slim down the bill and create a more graceful, elegant solution. Just for your recollection as to what problem we're trying to solve here, as many of you know, because the mail is federal, it has been traditionally treated as a federal offense when someone steals the mail, or the arrow keys more dangerously that are used to open up the blue boxes. And we've seen an incredible amount of theft, usually armed theft of these arrow keys. And so working with former Delegate Barron, we've put together this package. And in an effort to streamline it, I worked with the U.S. Attorney's Office to mimic the federal law in our state law so that what's happening is Eric is generally not prosecuting any mail theft unless I apologize. The United States Attorney is generally not prosecuting any mail theft where the loss is below $1 million. And with our local prosecutors not having the tools necessary to get that job done, it leaves a lot of terrible crime unprosecuted. So this is what it's trying to fix. In working with the U.S. attorneys and the AUSAs who prosecute this, we came up with this solution that you see in front of us. It passed out of the Senate unanimously. We then got word from our local state's attorneys that the way it was done would actually make things unintentionally worse. And so please don't pass this in its current posture. I am aware that we are running out of time here. My hope is that I can get together with Mr. Lancaster, Ms. Rossmark, the House sponsor, and we can come back to you with amendments that try to do what this does, which is have a more elegant solution than the original bill without unintentionally doing damage to the tools that prosecutors currently have to prosecute mail theft.
Questions?
Hi, Senator.
How are you?
Good. How are you? If it would be possible, if you can include me in that conversation. I know we talked a little bit about a similar bill I had with porch piracy, and I'm noticing some of the current reprint we have that you just said not to print, but I would be curious, same situation. We know that, you know, it's a federal crime to tamper with mail, but unfortunately it's not for packages, and they should have the same protections. And so definitely would love to be a part of the conversation to see how package thefts can have the same protections that mail theft has currently on a federal standard, and how we deal with that on a local level.
Absolutely.
And I know we talked about it a little bit before. Just a quick question though, as it relates to your bill, that 15, that fine, I guess that would change, or is that supposed to be taken out, the imprisonment for 6 days and a fine of $15? I'm sure that would be removed, and then, or is that, am I reading this?
I think that's
I'm very confused.
Yeah, I mean, ultimately, this is going to get changed
Sure, I
again.
know.
So I don't want to invest too much time into this,
Sure,
but
absolutely.
basically the idea was to create a 2-level offense.
Yes.
Where someone who just kind of does this once off at
Okay.
one house is punished in one fashion, and
Right.
someone who is doing this as part of a more organized operation is punished in a different fashion.
Yes. Okay, I won't take up too much more time. I definitely just ask if we could just stay in communication, because I know I'm trying to deal with packages to get some of
Absolutely.
the same protection. So thank you. Thank you, Mr. Chair.
Seeing no other questions, thank you very much.
Thank you, Mr.
Vice
Chairman.
Chair. So that concludes the bill hearing on Senate Bill 373. Members of the committee, it's 2:52. We'll go to a voting session. Voting for, we're going to talk about the correctional ombudsman bill. We're going to vote on a bill that was held from last week. Going to do those things starting at 3 o'clock. So if you need a little break, now's the time to take it, but we're coming right back in at 3 o'clock to do those two things. Thank you very much. We'll be back in about 8 minutes.